A whole bunch of backers of Owen Benjamin on Patreon have brought arbitration claims against Patreon for Owen's removal from the platform. Patreon in turn sued 72 of those people in California state court, asking the court to prevent the arbitrations with an injunction. Patreon just lost. Let's talk about the 3 big reasons that they lost, and then let's talk about what comes next. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and today we're talking about the ongoing saga of Patreon and Owen Benjamin. Now, I summarized what's gone on so far, but let's talk really quickly about what this all means. So, Patreon has provisions in its terms of service that demand a couple things. And it's important to remember what these demands are. These demands are you agreeing to, if you're a Patreon subscriber, agreeing to give up some of your rights. And the 2 important rights here are, first, the right to go to court with Patreon. You are agreeing to not go to court, but rather to go to a binding arbitration process, specifically through the JAMS arbitration services, and you are submitting to the jurisdiction and rules of JAMS. That is one thing you've given up. If you did not have that provision, you could bring your lawsuit in whatever jurisdiction is appropriate, maybe even your own, forcing Patreon to come to you. But now you are agreeing to go to Patreon and to engage in the process that they chose, which is the JAMS arbitration services. The second thing you're giving up when you sign that, when you click agree on that terms of service for Patreon, you're giving up your right to litigate your claim as a group, or more commonly known as a class action claim. Now, you can't bring a class action lawsuit against Patreon because you can't bring a lawsuit against Patreon. You must go through the arbitration process. But arbitration is created as sort of an express route through the court system that's private, it's faster, and it may be more efficient or effective for the parties involved. So its rules are based, at least loosely, in existing law. And so JAMS does allow the grouping of claims, basically creating a class action arbitration. But you give up that right when you go and click agree to the terms of service of Patreon. So you're giving up your ability to bring a lawsuit, and you're giving up your ability to act as a class. Patreon does this because they are afraid of people acting in concert. This has come back to bite Patreon in a terrible way for them, because now they have to deal with any of these claims individually. And in Owen's case, that's about 100 people filing individual arbitrations. Why does this matter? Why isn't it better to deal with them individually? Sort of. Maybe. Not really for them. So arbitration is private, and it costs money because you have to hire all of these people. They're not publicly funded judges. There's not a publicly funded courthouse. All of this stuff has to be paid for, and there's no taxes paying for it already. So when you file an arbitration in JAMS, it costs somewhere around $3,000 total. Now, when you're in the expedited consumer versus business process that Patreon, again, has you agree to in their terms of service, you as a consumer arbitrating against Patreon, you are actually granted a big benefit. You only have to pay $250 of the arbitration costs, and the rest of it is shouldered by Patreon. So that means that you pay $250 and Patreon pays $27.50. This recognizes the disparate resources between a big company and an individual person, right? That makes sense. Well, suddenly, when you have 100 of those, that $2,750 bill goes up to $275,000. And that's just the filing fee. That doesn't count the professional fees. In arbitration, you have to pay for the arbitrator. You have to pay some excess, a surcharge on all fees that you pay as part of the overall arbitration management fee. And there may be other fees involved as well, plus you're paying your own lawyers. So the bill tallies up very quickly. Now, last year, California enacted a new piece of law that says that all of those arbitration costs have to be paid within 30 days of the invoice. Otherwise, or of the due date on the invoice, I should say. Otherwise, you are in default of the arbitration, and that default carries with it further monetary sanctions. So all of this was filed back in January. Patreon, I'm told, has made some payments, and they were in March. Whether or not they're in default remains to be seen. It depends on how the invoicing process works and how that's interpreted, and that is something we may find out and we may not find out. What we do know is that Patreon does have to pay for all of these individual arbitrations. Now, this is what Patreon was asking the court to prevent, because even if they paid the initial filing fees, there are more fees that come as the arbitration commences, and they have a rolling obligation to pay those fees within 30 days of the invoice due date, right? So as more fees rack up, the jams will send bills to Patreon and they will have to pay them as they go. If at any time they default on that, they're in default of the arbitration and risk losing the arbitration and being liable for even more costs and fees to the individuals. So this is a really high stakes game for Patreon, and they are losing it right now. This is, again, what they've asked the court to stop. Please stop these arbitrations. It's not fair. It's going to cost us too much. So here's what the judge has said. Importantly, Patreon's request for a preliminary injunction is denied for several reasons. There's three. Those are the several reasons. There's three, and we're going to talk about them one at a time very quickly, and I'll hit the main points and I'll explain why they're important. First and most important, Patreon fails to show that it will suffer any irreparable injury or interim harm if an injunction does not issue. Think of an injunction like a restraining order, because they're the same thing. So in a restraining order, if you say that I need a restraining order because if this person comes near me, they will cause me harm that can't just be remedied. Like maybe they'll kill me, or maybe they'll cause me a severe or permanent injury, or leave permanent scarring because they're violent. Something like that. That's why you need the court to issue a restraining order, is to protect you from injury that can't just be made up with some simple gesture. Right? The same thing is happening with this injunction. Patreon has to show the court that they will suffer some irreparable injury if they are not granted their injunction, and they have failed to do so. Patreon's argument over irreparable injury is merely that they will incur significant expense in fighting these arbitrations. The court's response, that was merely having to incur expense in order to participate in arbitration proceedings, is not irreparable harm. And there's an unspoken line there from the judge, and it really comes through in the next 2 points, but it's especially when you are the drafting party who put the arbitration provision in the contract. That's the unspoken thing here. You asked for this. You asked for this, and you asked the court to stay out of it. Now you want us to step in. Doesn't work that way. So the second point we've got here is that Patreon fails to show a reasonable likelihood of prevailing on its claims. Even if Patreon were correct that defendants' claims are not arbitrable, those issues are for the arbitrator, not the court to decide. So JAMS has a process. It's in their rules that JAMS has a process for determining whether or not JAMS has jurisdiction over the issue and whether or not the issue is arbitratable in the first place. Okay, so JAMS determines that. Since they have incorporated the JAMS rules into their contract by reference, the terms of service contract we're talking about, since they've incorporated by reference the JAMS rules and demanded that you submit to them and promised that they would submit to them, now the court doesn't have any say. You picked arbitration. You don't get to come to us when it's not working out. So the arbitrator has the authority to determine jurisdiction and arbitrability as issues as a preliminary matter. Now, the judge throws in a little jab at Patreon here, and they deserve it. Indeed, Patreon asserts that a JAMS arbitrator has already ruled in its favor in a similar case. So as part of Patreon's argument for why they shouldn't have to deal with this, they say they ruled for us already. In which case they admit that these issues can be dealt with by JAMS and can be resolved favorably in favor of Patreon. That's a terrible admission for your argument. It's terrible to say, we need you to step in because this is unfair. Look, as evidence, we've already dealt with this and it went our way. The judge is like, wait a minute, what? What do I care? Then you've got it. You know they can fit. You know they can solve the problem. You know how to participate in the process, and you've already won on this issue elsewhere. So this was a big bad one for Patreon as well. And third and finally, California courts rarely grant the extraordinary relief Patreon seeks here. Once a dispute is submitted to arbitration, the California Arbitration Act contemplates limited, if any, judicial involvement. It is the job of the arbitrator, not the court, to resolve all questions needed to determine the controversy. Again, Patreon asked for this. More than asked for it, they demand it as a condition of using the service. So once they did that, they got the court out of the way of the relationship between Patreon and its consumer. Now, once this starts going poorly for Patreon, they run back to the court. But courts are like jilted exes. You didn't want me, you don't get to have me now. And that's a helpful way to think of it. If you try to shun the court and then go back when you're not feeling like you're getting what you wanted, the court's going to say, look, can you get your remedies where you are? Yes, of course you can. Did you ask for those things? Yes, of course you did. Will you be somehow irreparably harmed if you don't get it? We don't see how. Look, you got to pay money, but you got to pay money wherever you go. So that is the court's reasoning, the basic framework of the ruling. Those are the important points from it. The court does cite a case in some significant capacity, and that is Briggs. And it is a case about how the courts are allowed to intervene in arbitrations in California. So it's a very important case, and the judge leaned on it pretty heavily. So what happens next? Well, what happens next is Patreon will have to proceed in its individual arbitration against its individual customers. They cannot be grouped according to the terms of service that Patreon drafted, and they will have to deal with them all, and they will have to pay for all of it, as all of those people have paid their $250 upfront cost, and Patreon is on the hook for literally the rest. The only expenses those people will incur will be expenses related to their own representation in the arbitrations themselves. They, of course, could represent themselves, or they could try and aggregate to get one sort of arbitration team to deal with all of them. I don't know what they're planning on doing. I have no idea. It doesn't really matter at this point for Patreon. Patreon has to deal with all of them. They have to make the payments, and they have to make them timely, and missing any of them risks default for them, and that default is devastating. This is an extremely important case, and what just happened is a shot across the bow of big tech companies. Your terms of service are binding upon you, at least insofar as these arbitration and anti-class action provisions, and we can use them against them. And that is important because this is how we defend ourselves from things like deplatforming, from things like cancel culture. And it is a big win in this sphere. Even if they end up losing the arbitration, the threat of removing someone from the platform and facing thousands, potentially thousands of arbitration claims coming in, that should give them pause at least. Or we'll see some very interesting changes to their terms of service coming up. They've already changed it twice since this matter was filed. So that is pretty interesting. All right, guys, I hope you found this educational. If you did, please like, share, subscribe, hit the notification bell. No. I'm a lawyer, but I'm not billing you. Hit the notification bell and check out other videos on the platform. We cover all kinds of legal topics and a lot of it kind of in this internet content creation space. So if you like that stuff, please check it out. Please share it and spread the word. Patreon got wrecked. Absolutely wrecked. All right. Thanks for watching, guys. Have a good day. Peace. Peace.